Hey, it's me, Bastian, and in this video we're gonna be talking about digital patent infringement. Now, I'm a patent attorney and my main job is to obtain patents in the first place, to build up patent portfolios. And so for the enforcement part, which is today's topic, I've invited an awesome patent litigator. Please meet Thomas Gniadek. Hi, Thomas.
Hi, Basti. Thanks for having me on your show.
Great to have you. Hi, Thomas.
Hi.
So, can you quickly tell us who you are and what you do?
Sure. I'm a patent litigator and partner with the Simmons & Simmons law firm. I'm based here in Munich, Germany, and by education, I'm an attorney at law, so in German, a Rechtsanwalt. That means I have a legal background and I advise clients, help clients with litigating and enforcing patents, mainly in the tech field and with respect to electronics. And I have been doing this exclusively for about 15 years now.
Awesome. So that's exactly today's topic, because today's question is from Franz Josef Wagner, shared with permission, of course. And I'm going to read the question: how to enforce software implemented patents? How to prove that somebody's infringing my patent? So, Thomas, what can you tell us about litigating software patents in Germany? Does the litigation strategy differ in principle when software is involved?
In principle, not. No, in principle, not. So, and it's not true that it is harder to enforce a software patent as compared to any other patent, possibly in the tech or electronics field. So it's the same rules apply. And I also would say that the success rate is not different from any other tech patent.
That's good to hear. That's encouraging to hear, because, yeah, that's also a statement I hear all the time. Software patents are so difficult because you can never be sure, or it's difficult to prove that the other third-party infringers actually uses the patented invention. So when we're talking about standard essential patents, for example, I would suspect the proof is rather easy if mandatory features are involved.
If mandatory features are involved, yeah. Mm-hmm.
But what, on the other hand, if there's, let's say, more than one possible algorithm that produces the same result as seen from the outside, how can you prove then in these scenarios that the patent is actually infringed?
Mm-hmm. So certainly the production of evidence, the identification of evidence is a very important issue when it comes to litigating, enforcing software patents. I think it's very important to understand that under German procedural law, there are no really strict rules on how to obtain evidence, how to assess evidence, and how to qualify evidence, meaning is that piece of evidence, is that sufficient to prove infringement or not? Basically, in a nutshell, it is you need to convince the judge. And if you are able to convince the judge, your job is done. But there are no really strict rules how to do this. A second aspect is that under German law, that might be the same as according to any other law, but especially under German procedural law, you have to tell the truth. So there's an obligation to tell the truth. And litigators in our field usually, they comply with that. Meaning there's a certain way how to make submissions in patent litigation and how to respond to such submissions. For example, as a plaintiff, you would make a certain statement substantiating your patent assertion. You would say, the patent is infringed because this and that. And then the defendant cannot respond in saying, no, this is not true. He would need to say, no, this is not true because. And then he would need to tell another story, possibly a different story. And then you can, as a plaintiff, you can reply again and say, no, I think it's like this and that. And then the defendant has to reply again and say, well, no, I think it's like this and that. And by doing this back and forth arguments, in the end, the the facts which are really disputed in that litigation, they are really limited to just one or two decisive issues. And then you can, in the oral hearing, you can speak about this. And if you then consider these two facts, for example, how can you prove this? You're certainly right that the first approach would be, well, you have a certain result. You can see that result of a data processing, and you can tell as an expert in software patents, you can tell that this result is typically produced using this kind of algorithm, for example. And you would say this kind of algorithm, that is patent infringing. And now the other party would say, no, there are possibly two different algorithms, or there are two different ways how to achieve that result. How can you deal with this? For example, you could ask a private expert to produce a private expert report. This can then be submitted in the proceedings, and the parties would discuss that. And the judge would weigh this evidence and would basically, well, assess whether he finds that convincing or not. Another way is possibly getting access to the source code. So under our procedural rules, we have tools and can obtain access to the source code. Certainly under protection of confidentiality, but the source code can be assessed in German patent litigation. Of course, that is very important for getting clarity what kind of algorithm is used here. Possibly a last thing which is kind of interesting is you can use the results and the evidence obtained in parallel US litigation. So you can go to your US co-counsel, ask him about the evidence he uses in US litigation, and you can introduce that evidence in the German parallel litigation. That's also a very meaningful tool, I guess.
Okay. So there are a number of tools available, I'm hearing. Okay. Now, we've talked about patent litigation in Germany, which makes sense because Germany is a very relevant, very popular, if not the most relevant litigation venue in Europe, I would say, patent litigation venue. But what about the fact that digital innovations are kind of borderless, let's say, in the sense that, I mean, oftentimes the infringing software will maybe run on a server abroad in the cloud, or sometimes even you might not even have any idea where the server is located exactly because it's operated by a third party who is in charge of running the software. So I guess maybe there are two issues here. So first, what happens when the infringing software runs outside of Germany, for example, in the cloud? And secondly, what happens if it is hosted by a third party, not directly by the entity you want to go after?
Yeah, sure. So in principle, if you would like to assert patent infringement in Germany, you have to show that the patent infringing acts are actually performed in Germany. That's clear. However, with respect to software patents, we do have established case law, which actually helps you or helps the patentee, the plaintiff, in that regard. For example, if you have a certain server structure consisting of various servers which are located in the US, in Asia, in Europe, possibly in Germany, it's totally sufficient to show that, for example, one of these servers is located in Germany. That's one example. Another example is if you have a method claim protecting a certain software how to use the software. There is established case law that you do not have to perform all steps of that method in Germany. It is totally sufficient if just one step is performed in Germany. And possibly a third example would be even if you have the issue that all of these patent infringing steps are performed abroad, there is case law that under certain conditions it would be sufficient for patent infringement if the result of a data processing, if that result is delivered to, if is provided to Germany, or if that result can be accessed from Germany. Of course, you have to look at the circumstances of the specific case at hand. But as said, there's case law helping you in that regard.
Okay. So now you've talked about patent claims already, about method claims in particular, and that's oftentimes also what I see in software patents. So when you come from, let's say, a mechanical engineering point of view, for example, the patents typically have, let's say, an apparatus claim, which covers the physical device, the product, right? And maybe also a method claim, which covers either the method of manufacturing the device or the method of operating the device. And in many software patents, I see a similar claim structure. And what I'm always preaching is, people, please also include a claim directed to the computer program itself, a computer program claim, in addition to the apparatus claim and the method claim, because you get that at the EPO, at the European Patent Office, for free. And but my question is, what impact does it make, does this claim category make in a software patent litigation? So do you need the computer program claim, or are you just fine as a patent litigator with the method claim alone?
First, I would totally agree with you. It's certainly beneficial to have various claim categories covered by your patent. That would just help you to cover various infringement scenarios. And in that regard, the more the merrier. And I understand from what you told me that actually it's at no extra costs. So why not have various claim categories? Also, with respect to infringement, it might help you. So if you have a program claim, you can assert direct infringement. So the patent infringing acts you might want to show are the manufacturing of the program, the distribution of the program, the offering, the importing of the program, the use of the program. So you have a few options how to actually show infringement of that program claim. If you just have to rely on a method claim, that can also be fine. That can be okay, and possibly for the majority of patent litigation, that is totally sufficient. But in that respect, you would need to show that the method claim that this method is used. So you have to show that every single step of that method is actually performed by the alleged infringer. And then you also have the separate issue that in principle that needs to be done in Germany. So we discussed this before. And there is case law basically helping you to establish that patent infringement in Germany, but you just have then more issues you have to deal with. In a scenario where not all steps of that method are performed by the alleged infringer, possibly by a third party, by anyone participating in the alleged patent infringement, such participation may be attributed to the alleged patent infringer. So you can say, well, that third party objectively helps to do that patent infringement, to perform that method, and he also knows that a patent infringement is at hand here, or he had reason to know that. And in that regard, of course, he has to cease and desist, but moreover, he's also liable for damages because of that patent infringement. So a method claim, in a nutshell, can be totally fine. In the majority of cases, it's totally fine to just have a method claim, but you have to deal with more issues as compared to a program claim. So the advice would be, the more the merrier, get more claim categories.
Okay, makes sense to me. Now, when we talk about patent litigation, of course, there's no way to not address the upcoming unitary patent and the UPC, apparently. So, will that add any tools to your litigation toolbox specifically for software patents?
Well, great question. Actually, we don't know yet. What is a fact is that the UPC covers Europe, continental Europe. So it's just a huge market. And if you can assert patent litigation, if you can assert patent infringement before the UPC, you are able to win an injunction which covers all member states who participate in the UPC. So you win an injunction for the entire European continent, and you may be able to collect damages with respect to that entire market. So of course that is huge leverage, and it's certainly very attractive for patentees and for plaintiffs to bring cases before the UPC.
All right, awesome. Thanks a lot, Thomas. Now, where can people find out more about you, and where can they find you when they need a patent litigator?
Sure. You can find me on LinkedIn. You can find me on simmons&simmons.com, or you can just write me an email. So I see you display the email address there. Just send me an email. Thank you.
Okay, great. So, dear readers, if you've got a question, just put them in the comments below and I will add it to the queue for another video. And in that sense, thanks for watching and see you next time.